Welcome, kindred spirits, to a place of positivity, passion, and purpose. Welcome to our video on legal status of Jainism as a distinct religion in India. We're thrilled to have you here. Jainism is considered to be a legally distinct religion in India. A section of scholars earlier considered it as a Hindu sect or a Buddhist heresy, but it is one of the three ancient Indian religions. On 27 January 2014, the government of India explicitly awarded the status of a minority religion to the Jain community in India, as per section of the National Commission for Minorities NCM Act NCM 1992. Now, let's dig deeper into history of Jain demand for minority status and unveil the hidden treasures it holds within. The Jain demand for minority status is almost a century old, when in British India the Viceroy and Governor-General of India, Lord Minto, took a decision in principle of giving representation to important minorities in the central legislature. Seth Manik Chand Hirachand from Mumbai, an eminent Jain leader from Mumbai and the then acting president of the Bar of Digama Jain Sabha, made an appeal in 1909 to the Governor-General for the inclusion of the Jain community for representation in the council. Seth Manik Chand's petition was transferred to the Government of Bombay, and the Secretary to the Government of Bombay stated in his reply dated 15 October 1909 as follows. I am directed to inform you that a number of seats have been reserved for representation of minorities by nomination, and that in allotting them, the claim of the important Jain community will receive full consideration. In a memorandum by the representative of the Jain community to the Constituent Assembly in March April 1947, a strong appeal was made for the inclusion of the Jain community as a minority religious community. In his speech on 3 September 1949, Jawaharlal Nehru said, "No doubt India has a vast majority of Hindus, but they could not forget in fact there are also minorities: Muslims, Christians, Parsis and Jains." If India were understood as Hindu Rashtra, it meant that the minorities were not % citizens of the country. Jainism is mentioned as a religion, along with Buddhism and Sikhism, in explanation II of the Article 25 of the India Constitution relating to fundamental right to religion's freedom. On this issue, Jawaharlal Nehru, the then Prime Minister, in his letter dated, assured a Jain deputation that they need not have any misgivings on this clear constitutional position. The second stanza of Jana Gana Mana, Indian national anthem, clearly enunciates Jainism as a separate religious denomination in line with Hinduism, Islam and other religions. The Indian Supreme Court in 2005 ruled that Jains, Sikhs and Buddhists are part of broader Hindu fold, as they are Indic religions and interconnected to each other, although they are distinct religions. As we venture forward, let's examine recommendation of National Minorities Commission in detail and gain a deeper appreciation for its significance. In 1993, the National Minorities Commission arrived at their recommendation that the Jain community be declared as a minority religious community. It was in consideration of the following relevant constitutional provisions, various judicial pronouncements, the fundamental differences in philosophy and beliefs, theism, Shaivism, principi vis a vis Hinduism, and the substantial number of Jain population in the country. It resolved to recommend to the Government of India that the Jains deserve to be recognized as a distinct religious minority, and that, therefore, the Government of India may consider including them in the listing of minorities. Moving on to the next segment, we have the PATIL judgment. In 2005, the Supreme Court of India declined to issue a writ of mandamus towards granting Jains the status of a religious minority throughout India. The court, however, left it to the respective states to decide on the minority status of Jain religion. In one of the observations of the Supreme Court, not forming part of the judgment, the court said, "The Supreme Court also noted that the state governments of Chhattisgarh, Maharashtra, Madhya Pradesh, Uttar Pradesh and Uttarakhand have already notified Jains as minority in accordance with the provisions of the respective State Minority Commissions Act." This cast a doubt on the independent standing of Jain religion. Scholars in the Jain tradition, as well as several groups amongst the Jain community, protested, and emphasized that Jain religion stands as a religion in its own right, while Hinduism as a mode of living and as a culture is to be found across various religions in India because of several common customs, traditions, and practices, but as religions, Hindu religion and Jain religion are distinct. As we enter this new phase, let's uncover the impact of 2014 national minority status granted on our broader topic. On 20 January 2014, the Government of India awarded the minority status to the Jain community in India, as per section of the National Commission for Minorities NCM Act NCM 1992. This made the Jain community, which makes for 7 million or 0.4% of the population as per 2001 census, the sixth community to be designated this status as a national minority, after Muslims, Christians, Sikhs, Buddhists and Parsis. Though Jains already had minority status in 11 states of India including Uttar Pradesh, Madhya Pradesh, Chhattisgarh and Rajasthan, in 2005 a petition was filed with Supreme Court of India by community representatives, which was also backed by the National Minorities Commission. In its judgment, the court left the decision to the central government. In the following segment, we'll be examining UP Basic Shiksha PARISHAD judgment in greater detail. In 2006, the Supreme Court opined that Jain religion is indisputably not a part of Hindu religion. In the upcoming section, we'll be dissecting illustrations noted by the Supreme Court and exploring its intricate connections to our topic. Jainism and other religions, illustrations noted by Supreme Court of India in the UP Basic Shiksha PARISHAD judgment. The para numbers refer to the paragraphs in the judgment. As we progress through this video, let's shift our attention towards Jawaharlal Nehru and uncover its hidden depths. On 3 September 1949, while addressing a public meeting at Allahabad, the first Prime Minister of India, Jawaharlal Nehru said, "No doubt India has a vast majority of Hindus, but they could not forget the fact that there were also minorities: Muslims, Parsis, Christians, Sikhs and Jains. If India was understood as a Hindu Rashtra, it meant that the minorities were not % citizens of this country." The said speech can be considered to be a clarification on Article 25 of the Constitution of India. 10.2 On 31 January 1950, the PPS to the then Prime Minister of India sent a letter to the Jain deputation on behalf of the then Prime Minister, which reads as under, see adjoining image for original letter. With reference to the deputation of certain representatives of the Jains, who met the Prime Minister on 25 January 1950, I am desired to say that there is no cause whatever for the Jains to have any apprehensions regarding the future of their religion and community. Your deputation drew attention to Article 25, Explanation II of the Constitution. This explanation only lays down a rule of construction for the limited purpose of the provision in the article, and as you will notice, it mentions not only of Jains but also Buddhists and the Sikhs. It is clear, therefore, there is no reason for thinking that Jains are considered to be Hindus. It is true that Jains in some ways closely linked to Hindus and have many customs in common, but there can be no doubt that they are a distinct religious community, and Constitution does not in any way affect this well-recognized position. Yours faithfully, St. A.V. Pami, Principal Private Secretary to the Prime Minister. 10.5 Jawaharlal Nehru, in his book Discovery of India, mentioned as under. Buddhism and Jainism were certainly not Hinduism or even the Vedic Dharma. Yet they arose in India and were integral parts of Indian life, culture and philosophy. A Buddhist or Jain, in India, is 100% product of Indian thought and culture, yet neither is a Hindu by faith. It is, therefore, entirely misleading to refer to Indian culture as Hindu culture. Now, let's redirect our focus towards Dr. S. Radhakrishnan and discover its significance in our narrative. 10.3 Dr. South. Radhakrishnan, the former President of India, in his book Indian Philosophy Vol. I mentioned as under. The Bhagavad Purana does not endorse the view that Rishabhadeva was the founder of Jainism. It is highly doubted that Jainism prevailed even before Vardhamana Mahavira or Pasvanatha. The Yajurveda does mention three names similar of the Tirthankars Rishabh, Ajitnath, and Aristani, but the Vedic definitions are different from the Jain definitions. 15. Dr. Radhakrishnan, who edited the 6th volume of the Cultural Heritage of India, mentioned as under. The Jains claim quite a great antiquity for their religion, but it cannot be competed with the antiquity of Sanatana Dharma. In the earliest Brahmanic literature are found traces of the existence of a religious order. As we progress through this video, let's now turn our gaze towards Freedom of Religion Bill controversy in Gujarat. The Freedom of Religion Bill was a controversial bill passed by the Gujarat State Assembly. The bill was passed in 2003. An amendment to the bill was passed on 19 September 2006 which banned the forced conversion from one religion to another. The Anti-Conversion Act passed earlier was not clear on what forced conversion meant and to whom should it apply. Under the amendment bill, a person need not seek permission in case he is converting from one sect to another of the same religion. It clubbed Jainism and Buddhism as denominations of Hinduism, like Shia and Sunnis are of Islam or Catholicism and Protestantism of Christianity. The move evoked strong protests from the state Jain, Buddhist and Christian communities. The National Commission for Minorities also criticized the Gujarat Assembly's decision to club Jainism and Buddhism with Hinduism, terming it to be in contravention of its 23 October 1993 notification classifying Buddhists as a minority community. Ultimately, on 31 July 2007, finding it not in conformity with the concept of freedom of religion as embodied in Article 25(1) of the Constitution, Governor Nawal Kishore Sharma returned the Gujarat Freedom of Religion Amendment Bill 2006. The governor held that Jainism and Buddhism are recognized as religions rather than denominations of Hinduism, something that the amendment bill sought to wrongly convey. A press release issued by Raj Bhavan said the proposed amendment would amount to withdrawing the protection against forceful or inappropriate religious conversions, particularly in case of Jains and Buddhists. The release cited large-scale protests from different religious and social organizations, especially from the Jain and Christian communities, in indicating toward the unacceptability of the proposed amendment. In the upcoming portion, we'll be dissecting chronological order of various court judgments on Jainism as a separate religion to gain a comprehensive understanding of its implications. 1. 1927. In 1927, Madras High Court in Gatapa v. Arama and others reported in AI on 1927 Madras 228 held that Jainism as a distinct religion was flourishing several centuries before Christ. Jainism rejects the authority of the Vedas which form the bedrock of Hinduism and denies the efficacy of the various ceremonies which Hindus consider essential. 2. 1939. In Hirachand Gangji v. Ruji Sodpal reported in AI on 1939 Bombay 377, it was observed that Jainism prevailed in this country long before Brahmanism came into existence and held that field, and it is wrong to think that the Jains were originally Hindus and were subsequently converted into Jainism. 3. 1951. A division bench of the Bombay High Court consisting of Chief Justice Chadla and Justice Gajendra Gadkar in respect of Bombay Harijan Temple Entry Act 1947 CA 91 of 1951 held that Jains have an independent religious entity and are different from Hindus. 4. 1954. In the Commission of Hindu Religious Endowments, Madras v. Sulakshmindra Tirtha Swami Sushirama reported in AI on 1954 SC 282. This court observed that there are well-known religions in India like Buddhism and Jainism which do not believe in God, in any intelligent first cause. The court recognized that Jainism and Buddhism are equally two distinct religions professed in India in contrast with Vedic religion. 5. 1958. In well-known Kerala Education Bills case 1957 reported in AI on 1958 SC 956, this court held that to claim the minority rights, the community must be numerically a minority by reference to the entire population of the state or country where the law is applicable. In that way also, the Jain community is eligible for the claim. 6. 1968 in Commissioner of Wealth Tax, West Bengal Pheasant. Kompakumari Singhi and others reported in AIR 1968 Calcutta 74. A division bench of the Calcutta High Court observed that Jains rejected the authority of the Vedas, which forms the bedrock of Hinduism, and denied the efficacy of various ceremonies which the Hindus consider essential. It will require too much of boldness to hold that the Jains, dissenters from Hinduism, are Hindus, even though they disown the authority of the Vedas. 7. 1976 in Aryasama Education Trust, Delhi and others v. the Director of Education, Delhi Administration, Delhi and others reported in AIR 1976 Delhi 207. It was held as follows: not only the Constitution but also the Hindu Code and the census reports have recognized Jains to belong to a separate religion. In the said judgment, the court referred to the observations of various scholars in this behalf. The court quoted Heinrich Zimmer in Philosophies of India, wherein he stated that Jainism denies the authority of the Vedas and the orthodox traditions of Hinduism. Therefore, it is reckoned as a heterodox Indian religion. The court also quoted Jain North Farquhar in Modern Religious Movements in India, wherein he stated that Jainism has been a rival of Hinduism from the beginning. In the said judgment, in conclusion, the court held that for the purpose of article, the Jains are a minority based on religion in the Union Territory of Delhi. 8. 1993 in Before Noon Jain College v. Government of Tamil Nadu 1993 1 MLJ 140. The court observed that it is also an admitted fact that the Jain community in Madras, Tamil Nadu is a religious and linguistic minority. 9. 2005 Supreme Court of India gave verdict that Jainism, Sikhism and Buddhism are distinct religions, but are interconnected and interrelated to Hinduism, so these three are part of one broader Hindu religion, based on the historic background on how the constitution had come into existence after. 10. 2006 Supreme Court of India found that the Jain religion is indisputably not a part of the Hindu religion. As we enter this new phase, let's navigate the complexities of list of states in which Jains have been declared as minority and discover its practical applications. 1. Maharashtra, which has the largest population of Jains in India. 2. Karnataka 3. Gujarat 4. Madhya Pradesh 5. Uttar Pradesh 6. Jharkhand 7. Delhi 8. Uttarakhand 9. West Bengal 10. Andhra Pradesh 11. Haryana 12. Tamil Nadu 13. Punjab 14. Assam 15. Rajasthan. Share this video with your friends and spread the knowledge.